And you probably rightly think that you're enough degrees removed from the front lines of a project that there are lots of other people that are going to protect you in the event that there is a problem on your project. And you're probably right to a great extent. But what does that really look like? What does it look like to be several layers removed from the front lines and have all sorts of contracts that are in your favor, layers of indemnity? The contracts are not self-enforcing. So you may have 5 contracts between you and the project that all give you rights of indemnity, but a person has to raise their hand and take action on those contracts. I'm being extremely facetious here, but a contract is not gonna call your adversary and make them do what you need them to do, or point a gun at them. People have to take action to exercise their rights. So what does it look like, for example, for you to have lots of indemnities in your favor on a project that might have a lien? Typically, if a general contractor has liens from its subs, somebody is going to be on top of them to say you need to post security, whether it's a letter of credit or cash security, or maybe to go and buy a lien bond. But the sureties that write those sort of lien bonds are going to take a good look at the balance sheet of a general contractor. And if they no longer have the balance sheet, if they no longer have the liquidity to get the lien bond, if they no longer have the ability to post security for you, then what do you really have, with all those paper rights? Not a lot. And in these days, in these strange times, your contractors and the various people that are involved in your project may be less solvent next month than they are this month. So now is possibly a good time to re-examine whether it's in your strategic best interest to be more proactive. Again, this is not a time for panic, but strange things happen in these economic downturns. In the last one, a decade ago, I was involved in a nursing home project representing the owner and the general contractor on the project, which was over 100 years old, a great general contractor. It became insolvent, went bankrupt in the middle of the project. And thankfully, there were performance and payment bonds in place, and we were able to steer the project to a good completion, which is really where I think most of your interests lie in this. What everybody on the call has in common, I think, is the need to see the projects completed. But it's important to understand sort of the economics of the way that construction is done, not at your investment level, but at the lower level. Contractors, and this is not intended to be pejorative, their finances are a little bit of a house of cards because they extend credit on a monthly basis. They do the work first and they get paid second. And so even the most reputable contractors sometimes have a little bit of a challenge managing their cash. And it's possible that your money on a particular project might be used by a contractor for another project if the needs are more pressing. So, I think that it's time to think about who is on the front lines of these projects, who is going to protect you, whose balance sheets protect you, what are those contract rights, and is there something that you want to do now? And since the people on the call are so far removed from these projects, I would suggest one thing for you to consider is possibly triaging your projects. Having your team report to you on, if there's smoke, is there fire, on 1% of your projects? What's the one project in 100 where you think that maybe there's something going on that you might like to monitor more closely? Get adequate reporting from them. And get proactive, more so perhaps than you normally would, in order to ensure that the projects get completed and you're able to realize the gains of your investment. One thing that's true, at least in Illinois, where I'm located, is that liens tend to come a few months after trouble on projects. And so if you, for example, are seeing lien claims on your projects and by the time it reaches your awareness, you might be, 3-4 months into a real, problem. Maybe the contractors become insolvent or something like that. So, I would suggest that you may wish to consider having your team triage your projects, figure out which ones require a little bit more of a close look, find out what sort of reporting you want from them, are there lien claims? Is the project on schedule? And in the event that there is a concern, maybe you and your team, pick up the phone, write some letters. Some circumstances you may want to consult your counsel, but the thesis of this presentation is whether it's in your strategic interest to be more proactive than you usually are. And that's something that I think that you may wish to consider for yourself, even though you are probably correct in assuming that you are well protected, being several degrees away from the project. But of course, we all do need to see these projects completed. I know that's certainly a very important aspect of your business model, everyone who's on the call. Jensen, why don't we move on to the next slide here. So I'm going to touch on just a couple issues here. First, I'm going to talk about mechanics liens, and one thing I'll say is that they're intensely state specific. You know, I have litigated, arbitrated, mediated cases across the country, but I've never recorded a mechanics lien outside of Illinois because it is so state specific. So you shouldn't take to the bank what I'm telling you now. You should think about talking to your lawyers or whoever else typically works with you on the project in the state that you're in. And also, liens are very different on public projects versus private projects. I'm going to be talking about privately owned projects. So what is a lien? And I think a lot of people here on the call might think of it as a piece of paper. They might think of it as an annoyance, something that you hear, oh, there's a lien on the project. But what is a lien really? On private projects, at least in Illinois, a lien is kind of similar to a mortgage. You record your payment claim in the property records, and in the event that you don't get paid and you're a lien holder, if you have a good claim, you can ask the court to sell the property, and the proceeds of the sale go to pay off the people who have lien claims. So thinking about who's on the call here, you know, whether you're on the debt side or the equity side, I recognize your interest might be a little bit different. Certainly, if you're the sort of investor that makes a loan and takes a secured interest in the property through a mortgage, you might have much more direct concerns about a foreclosure action, because at least theoretically, the security that you relied on to make your loan could theoretically be sold out from under you by a court and used to pay other parties. So I know that not all of you have the same, you know, interests. Not all of you loan money and take a mortgage interest in the property. But again, what we all have in common, no matter who you are, is a need to see these projects completed and completed timely. And liens tend to be an indication of a project that might not be well. You know, it's you know, taking the temperature and finding out which of your projects have a fever, and there's some indication that it might be sick. You know, liens can lead to all sorts of things. You know, when there is a sudden illiquidity, when any one of the contractors doesn't have the ability to meet its obligations, can't pay for the labor that you need on the project this particular month. You know, if they wind up filing bankruptcy, these are things that can really throw a monkey wrench in your project. And so, you know, it might be a good idea for you to talk to your team and say, I want to just know a little bit more about which of my projects have liens on them. You know, and what do I mean by being proactive? It can be different things for different people. You guys are not on the front lines. I am much more so. You know, but on the last project where I represented a developer, there is reason for us to believe that the general contractor absconded with certain of its funds and also placed material orders for materials that were going to be diverted to other projects. So when I saw that, I thought to myself, what kind of a letter might I like in my file a year from now? You know, and I wrote a letter that said, you know, this is what I think is happening, and let me know within a week whether or not you think this lien claim is valid. And if you don't respond, I'm going to assume it is. And that enables me, if it's in my client's strategic interest to do so, to go ahead and settle the claim without having the risk down the road that the party that is ultimately going to be responsible might say, well, why did you do that so quickly? You didn't give us a chance to tell you why the debt was no good. So, you know, there are things that you can do proactively now, and I recognize the example that I gave is much more a lawyer on the front lines than a lot of you are. But again, you know, where there's smoke, sometimes there's fire. So I would think now might be a time for you to at least reconsider your strategy of looking at your investment portfolio and seeing, you know, which are the projects that you might want to pay a little bit more attention to. You know, I want to talk a little bit about surety bonds, and historically you might have been more passive with bonds, but now might be a time to be a little bit more proactive, or at least to consider getting more proactive based upon additional reporting that you might ask from your team. You know, one thing that you should understand is that there are a number of ways that the people on the front lines of a project can destroy the value of a bond. This is true largely for performance bonds. To some extent, it's true for payment bonds. I'm going to talk about them both in a little while, but you shouldn't assume that a project that has payment and performance bonds that it's a panacea or a perfect solution. Right now on your projects, there might be things happening on the front lines that could be giving the surety, the company that writes the bonds, the right to try to contest whether it really owes obligations to you. And this is again about creating good facts for yourself. One tip before I get into some more specifics about bonds is the way that sureties underwrite bonds. And I don't always require in all my projects that contractors be bonded. Sometimes it's absolutely in my client's strategic best interest. But one thing I found is that if a surety is willing to write a bond for a contractor, that's typically an indication of good health of the contractor. So whether or not I require bonds on my projects, I do sometimes like to ensure that the contractors are bondable. So I might say, get me quotes for bonds, show me that you can. And if they come back and they say, yeah, I got all these sureties that are willing to write bonds for me, at least I have some, sort of gut check indication that they might have good financial health. It's a good litmus test for financial health. So payment bonds, what are payment bonds? The obligation of the surety there is to guarantee payment to certain suppliers and subcontractors. And, there are bonds on public projects and bonds on private projects, and they're different. But one thing that you should understand is that there really isn't any kind of standard bond form. Each bond is different. And so more so than other things like insurance products, you really need to read the language of the bond in order to understand, what your rights are. And you also need to understand that the bonds are construed with the contracts that they relate to. So you really have to read a bond and the construction contract as one single instrument to understand what the surety's rights and obligations are. So what's something that you might want to do on a troubled project? If there are payment bonds in place and there's some indication that there are liens or there are payment problems, the subcontractors that might be wanting to make those claims might not know that there is a bond available for them. So making sure to get a copy and having it distributed, or having your team make sure it's distributed so various parties can go after a surety, get paid and not jeopardize your project is one action item. But I think that because we're all most interested in seeing the projects timely completed so that you can realize that the tax credit benefit, performance bonds are really important for you all. And the obligation of the surety for performance bonds is to fulfill the obligations of the defaulted principal, which is generally the general contractor. A lot of people don't realize that performance bonds actually don't end when projects end. So again, you got to read the language of the bond. But in many cases, if there is a contractor that doesn't comply with its warranty obligations years after the project is over, sometimes you can threaten a bond claim, and that's a pretty significant lever to get their attention. But the obligation of a surety for a performance bond does not arise until when the contractor is declared to be in default of the contract. And then the surety comes in and it stands in the shoes of the contractor with all of its rights and obligations, okay? So typically it's a project owner, a developer that's going to give a notice of default to a surety, but sureties need not wait for the declaration of default. Many of them are monitoring the health of the principals, the contractors that they write bonds for. And they can be proactive. They can say, I'm going to step in and I'm going to try to mitigate my losses. And one of the reasons that they can do that, and I think this is important for you to understand, is that unlike insurers, which expect to take losses, sureties never expect to take losses. They don't write actuarial premiums and expect to collect premiums and take certain losses in profit. Sureties expect to never take a loss. So when they write a performance bond, they're going to have an indemnity agreement with the principal, the contractor, and in many instances with the the individuals behind the contractor, because they don't intend to take losses. They intend to come in and collect whatever money they pay out. And so if they a surety does get involved in your project, they have access to the contract funds that would be paid out to the general contractor. And so this is one of the point here is that sureties, unlike insurers, have more ability to try to say that something on the front lines of the project have voided the bond. And changes to the bonded contract can materially increase the surety risk and give them these defenses. I'll give you some examples. If the developer on the front lines gives the general contractor a month extension on substantial completion without letting the surety know, maybe there's something there that the surety might have wanted to know about. Maybe they would have wanted to be proactive. Maybe they would have wanted to step in and say, stop paying the general contractor. I get the right to those contract funds. I'm going to help you complete the project. Oh, but you've given them all this extra time, and somehow you voided, our ability to have no more risk than we signed up for at the beginning. Change orders, things of that nature. If the risk that the surety is dealing with because of material changes on the front lines of the project are occurring, sometimes the bonds can be worth a lot less than you think. And so what is the surety's obligation upon the default of its principal? Well, one thing it can do is it can settle with the people that it owes rights to. It can cut a check, or it can step in and it can complete the project, or it can finance the contractor, and say, we're going to prop up the GC so that they can get the project done, which is in many cases is better than starting over with a new contractor. Or in some cases, the surety can say, I'm going to give you introduce you to a new contractor. I'm going to give you a new bond, and this new contractor is going to complete the project for you. Or sometimes they can do nothing and deny your claim. And, again, changes to the bonded contract that materially increase surety risk are things that can, take away the value of the surety bond. So there's certainly, no need for panic. And I don't think that what I'm telling you is any different now than it has ever been. This is just the reality with bonds. But if you're sitting back there thinking, I'm removed from the project, I've got bonds in place, it might be the case that you will want to have your team triage your projects, figure out the 1% where you want to be a little bit more proactive, and then go read the bond. Figure out what the language is, read the contract, ask for a little bit more reporting, try to find out whether the project is on schedule if there's other indicia of problems. Quickly, moving on to insurance policies, the only point that I would make, because I see so much discussion about builders risk insurance and other types of insurance products, people making claims due to COVID-19, is that, and this is a wild, generalization, because there's all kinds of insurance lawyers, but generally there tend to be two kinds: the kind that represent insurance companies and the kind that represent policyholders against insurance companies. And if you are involved in making an insurance claim, you might want to consider involving a pro policyholder insurance attorney that can read your project and figure out exactly where the center of the bullseye is for communicating with the insurer. Because sometimes I'll find that my clients will begin to casually communicate with the insurer in a way that they don't understand is potentially creating defenses that the insurer can use to deny the claim. The specific words that you use to describe your circumstances can be very important. Now, I am not an insurance attorney. I am not a pro policyholder insurance attorney, but I have a bunch of friends who are. So if you have a considerable loss, you're thinking about making a claim, thinking about who is going to be the public face of your claim and communicating to the insurer in a way that is most likely to trigger coverage rather than to trigger some sort of an exclusion is a good idea. Again, I'm being facetious here, but I almost think that people should be Mirandized before they start talking to their insurance company. You have the right to remain silent. Anything you say can and will be used against you. Just to understand that if you're firing off casual emails to an insurer saying, I might have a claim here, you might be stepping in a bear trap and giving them reasons to deny your claims. And then the last bit of this is really just about contract rights and obligations. Again, contracts are not self-enforcing. Your contract's not going to grow an arm, and point a gun at the person that, owes you some obligation. I'm obviously being very facetious here. Contracts are something that people have to enforce, and you need to understand what your rights and obligations are. Does it make sense for you to exercise your rights? Do you have a right to request proof of contract or solvency, their balance sheet? Do you have an obligation to give somebody notice under a contract? You know, you don't want to find your project has problems and wish that 6 months earlier you had written a letter that never got written. So that's it for me, Jensen. Thank you again for the opportunity to put a few comments in your presentation.
Well, thank you very much, Jeremy. It appears that we're closing in quickly on the hour, and I suspect many of you may have engagements, starting at